In the case of Mallet versus Sharmon, this one is an important, very important decision for doctors. It is an important decision regarding a person who comes to a facility in an unconscious state and carries a card stating unequivocally, that is, unambiguously, he has a card, unambiguously, the person cannot talk. Then he comes with somebody, and it is stated on it, don't give me this medicine, or don't administer blood to me under any circumstances. In this case, the person said, don't administer blood to me under any circumstances. If you say under any circumstances, that means he has closed the opportunity. But if she had said, don't give me blood, then you can give several interpretations. Don't give me blood. You can say that, oh, when I cannot talk, or when this will happen, when this will happen. That is how we give our interpretation. But this one, the woman has closed all avenues under any circumstances. Then the facility did not administer blood transfusion to her to save her life, as the writings on the card were clear and not susceptible to two or more meanings. There was no ambiguity. Then the family sued the doctor for not administering blood transfusions to the patient who died as a result of the refusal of the blood transfusion. This one was in Canada, the Ontario court. I'm quoting what they said. Very, very interesting. Quote, the doctor cannot be held to have violated either his legal or professional responsibility towards the patient or the patient's dependents when he honors the Jehovah's Witness card and respects the patient's right to control her own body in accordance with the dictates of her conscience. The onus is clearly on the patient when members of Jehovah's Witness faith choose cards intended to notify doctors and other providers of health care that they reject blood transfusions in an emergency. They must accept the consequences of their decision. Neither they nor their dependents can later be heard to say that the card did not reflect the true wishes of the person who brought it. If harmful consequences ensue, the responsibility for those consequences is entirely theirs and not the doctor's. But where it is susceptible to two or more meanings and the doctor fails, then the doctor will be held responsible. So where a patient visits facility with a card rejecting specific medical treatment and its content is ambiguous, the doctor can proceed to do what the person objected to on grounds that the non-consent document was ambiguous. Once you can give two or more meanings. Example statements such as, do not administer blood transfusions on me, can have several meanings, such as do not administer on me where there is an alternative. Because that one, it is vague. In Ghana, as in UK, a child and an adult who by reason of sickness or any other cause is unable to give consent for medical treatment shall not be deprived of medical treatment, and the medical practitioner attending to the person shall not require the consent from any third party. Where the family members of a child or an adult resist treatment or refuse to give consent, an application may be made to the High Court for appropriate orders to be made in the exercise of its wardship jurisdiction. Now, we are going to look at a very short. Does consent vitiate negligence by the health provider? Consent. I have consented. So can you do me whatever you want to do? You use me as a guinea pig. The old position in the UK was that where consent was given and surgery was done without disclosing the consequences, and the patient subsequently had serious medical complications, that will not invalidate the consent to the treatment, and action for battery and negligence shall fail. That was the old position. In the case of Charlton versus Garson, where the plaintiff who was sick gave consent to the defendant to undertake surgery on her body, after she had done an earlier surgery which gave her only temporary relief from pain, the defendant, before the second surgery, though informed the plaintiff of the method of treatment, did not tell her the possible consequences on her. The second surgery caused the plaintiff to completely lose the sensation in her right leg and made the pain worse. The plaintiff sued the defendant for battery and consequence. The English court held that plaintiff gave consent to the defendant, which was rare consent, and it was inappropriate for the plaintiff to bring an action against him where he had acted in good faith and in the interest of the plaintiff, but was negligent in disclosing a risk inherent in the recommended treatment. That was the old position. For example, for the purposes of tort of battery, there was no consent given to the defendant, was not required to inform the plaintiff as to every risk associated with the act. Now, people continue to use this decision, but this decision has been overruled to be a bad law. The old position was followed by the position enunciated in the case of Bolam versus Friend Hospital Management Committee. Ghana, until 2005, we were using the Bolam test. So I'm going to talk about what we mean by the Bolam test. The Bolam test established the ratio that healthcare professionals are not liable for negligence, provided it could be established that he or she acted in accordance with a practice accepted at that time as proper by a competent body of medical opinion, despite the fact that some other medical experts use different procedure. So if it were Ghana, we ask Ghana Medical Council, then Prof. Nkobia in his team will say that the standard is that once you do 1, 2, 3, they say, oh, then the Bolam test is that this is the standard that has been set by the council. And once you operate within that one, we cannot bring an action against you. But this test has been used in Ghana, but now it has ceased to be a good law. Ghana, it was used in Jan versus Ashanti Goldfields Corporation. So when it does happen, the judge is not required to call the Ghana Medical Association, Ghana Pharmaceutical Association, or Nurses and Midwifery Council to come and tell us the standard. We are no more interested in the standard. The old position discussed above has ceased to be the true position of the law. And the true position was stated in the case of Montgomery versus Lancashire Health Board. This case brought about Patients Charter in UK. That is UK Supreme Court. When the Supreme Court was constituted, this was the first case in medical negligence that it handled. And it said that it will not follow all the old decisions. The Supreme Court said that Charlson and Garson and other decisions on mere consent have ceased to be a good law. And doctors have a duty to warn a patient about the consequences of treatment and give them the opportunities to choose from other alternatives. Tell me, we have A, we have B, we have C. If you go for A, this is the consequence. B, this is the consequence. C, this is the consequence. In the alternative, there is another facility here who have specialists in that area. You must tell them all these things. Don't say that we are in competition. You are not in competition. You are not in competition for anything. It is about human life. So if you don't have competent people, you must tell that person that we have this, but there's another facility here. I know that they have A, B, C, D, E. If you want to go there, you can also go there. But if you fail and you limit it to just yours, and even yours, you not tell the consequences, bear in mind you are going to be sued. And you know, when we talk about these cases, if you are not lucky, we can award about 1 million Ghana cedi. Because I believe you know how we work it out. If the person is about 30 years, you attend to the person. Ordinarily, the person has 30 years of purchase. We presume that the person will work up to 60 years. So we look at the 30 years of purchase. How much do you earn per month? Then the person says, I earn 1,000 Ghana cedis a month. So 1,000 Ghana cedis a month times 12 times 30. That is how we work it. Because year of purchase, if he were working, he would have earned income, and you have disabled him. And therefore, he needs the money now to invest against his future. Purpose of Patients Charter. The charter is meant to protect the rights of patients in the health service by ensuring that the highest quality, equitable, comprehensive health care. Please, the charter, the aim is to ensure that highest quality, equitable, comprehensive health care is made accessible to the patients. So if you are going to do anything that is below, that is higher, you are not meeting the standard, because it is highest quality, equitable, comprehensive. You pack all of them in a package and you tell the person, these are your rights. And it is for every patient. It is for every patient. In that sense, every patient who comes to your facility is deemed to have entered into an agreement with you, with that patient charter. You cannot say that, even where do you come from? Did I even ask you to come here? It is immaterial. Once the person was given the opportunity to come and the person came, you are bound. And patients are to be respected for their right of choice in respect of healthcare plans. You know, until recently, doctors they will monopolize everything. Who dare you to say that, doctor, what are you going to do to me? What are the consequences? You say, for two non-co, we man can buy. So here, every person who is sick, every person who attends a facility has a choice. And patients shall not be discriminated. Here we are trying to avoid discrimination. Patients shall not be discriminated on any grounds, particularly on grounds of culture, language, ethnicity, religion, gender, age, types of sickness, disability, and the responsibility imposed on patients for their personal and communal health to prevent, promote, and to use simple, creative strategies to fight diseases. Because if you are a patient and you go to hospital, you must also help yourself. When the regional director was here, he said something which was very, very interesting to me. When he said that we need to have good people, because when we join the profession, some of us are already arrogant, because immediately you are offered admission to read law, we start calling you a lawyer. We start calling you a doctor. Whether you pass or not, that is your name. And your mother or father, instead of asking you to do 1, 2, 3, he feels you are a doctor. Meanwhile, you have just been offered admission. And please, when you go home and you get opportunity, read Article 41 of the Constitution. If everybody in Ghana reads Article 41 in the Constitution, even once a month, Ghana will change. Responsibilities, because we always think about our rights. What about duties and responsibilities? The rights that the Charter seeks to confer on patients are the right to quality health care, irrespective of the location of the patients. The person may come from my village. Maybe because of the dusty nature of the road, he will come. You see, his clothing is very dirty. The right to full information. The next one is the right to full information on the patient's condition and management and the possible risk involved, except cases with urgent attention or in emergency situation. That's for emergency situation. If you decide to talk to the person about their right, at the time you are done, the person is gone. The patient must know if there are alternative treatment or facilities with experts. I'm talking about the Ghana Charter. With experts within the service that can provide a better service. At times, you may assess yourself. A doctor, maybe you may be a general practitioner, but this one will come, I will do. This one will come, I will do. You are using people as guinea pigs. And some of them may die, except that they may not know their rights. Then the next one the patient must know the identity and names of the caregivers. I have come to you. Let me know you. Who are you? You know my name. I must also know you. Who are you? I'm Dr. So-and-so. What about this one? He is a student. At where? At Konfanoche. Then you want him to do something. I will tell you, please, I will not allow the student to touch me. You cannot say that I'm too known. The law says it is a patient's right. Then, that one is quite interesting, but what can we do? Then, here we talk about, so if you are trainees, students, and serial workers, I must know all of you. And I may decide whether to permit you to work on me or not to work on me. At times, your name alone, you may mention your name, and I'll tell you, because of your name, I will not allow you to attend to me. Some of the lawyers here would understand me. When we are doing jury trial, and there is a charge of rape, and the jurors, if it drops a woman, say, object. Because it's about somebody who has raped a woman, and you are asking a woman to come and sit in to judge. Then, where the patient has given consent, he gives consent that I've given consent to you. You can use my sickness or the report from it as to teach students. I may come the next day to tell you that I've had a change of mind. Please don't use it. And you cannot say that you use it, because it is my information. I authorize you, and we can have a change of mind at any time. So once I come to tell you, you cannot use it. And the treatment that you are giving to me, if it is reduced, that means you are being negligent. And it is traceable to the fact that I told you I will not allow you to participate in the research or allow you to use my data. Now, if it is research, I can tell you I will help you, but I can withdraw my consent at any time. Then he shall be entitled to the most effective care. Please listen here. If I have given my consent and it is withdrawn for research and other educational purposes, and it is withdrawn, then the law is that he shall be entitled to the most effective available, despite his or her withdrawal for the research project. Why? Because if the law does not insist for highest, we are human beings. We will harbor hatred and will not give the person the required treatment. The other rights include the right to privacy during consultation. The right to privacy during consultation, examination and treatment. And in a case where notes made from the patient's case are necessary for teaching purposes, the consent of the patient must be sought. Any information about the patient shall be treated as confidential and shall not be disclosed to any person unless the information is required by law or is in the public interest. Somebody may come to you, you diagnose the person is HIV. Then you say, hey, this person is HIV. The question is it in the public interest? Is it one of them? And the answer is no. My first time in East Africa, and that was where I heard that, according to the East African people, diabetes is more scary than HIV. For them, they are scared of diabetes. Yes. Then the patient is entitled to know any relevant policies and regulations governing the facility he or she attends. I've come to your facility. You must tell me. There is a washroom here. If you go, you pay money. There is this, there is this. You haven't told me, and I'm going to the washroom. Or I went, I thought it was free. Then I'm coming out, then they ask me, pay 1 cedi. Meanwhile, I don't have the 1 cedi. If you had told me, I would have kept it to myself. So here, the patient is entitled to know any relevant policy and regulations governing the facility he or she attends. Then the patient shall be abreast of procedure for complaints and dispute and conflict resolution. You must tell the person, if somebody behaves to you and you think it's not acceptable, you can petition through this, you can do that, you can do that. How many of us do? Only God knows. Then the patient's security and personal safety and property within the confines of the facility shall be protected. You just write, you park your car at your own risk. That is what we do, the exemption clause. But this act says that no, it's not enough. Once I am a patient and I come there within the confines of your control, then you must ensure my security as well as my property. So those who write the exemption clause, you park at your own risk, and there's no security man there. You go and somebody has broken into your car. Now you can maintain an action against the facility. Then, if you attend to me, you must also tell me that you have a right to seek a second opinion. Don't make yourself that, as for me, apart from me, you go to any other place, you will die. I'm the only person who can save you. I'm your savior. Then the patients have rights, and the rights are inseparable from their responsibilities. And they are to cooperate with the facility and its personnel with respect to his or her own health. If you are a patient, you go, you start insulting anybody, they will drive you away. The client's responsibilities are to make full and accurate disclosure of his or her medical history for diagnosis, treatment, counseling, and rehabilitation purposes. Then you must permit questions that will help the facility to get additional information or clarification on the patient's sickness that they do not understand. To comply with the prescribed treatment, if you are giving this and you go to your pastor that morning and the pastor tells you, throw it away, let me pray for you. Report its adverse effects and adhere to follow-up requests. When you take the drugs home, you take and you think that it is worsening your pride, you cannot even sleep, you can't do this, you must go back and report to them. Even though they have given you a month, you can just go there a day or two to report, and the doctors and their nurses are supposed to accept you. They cannot say that we don't have an appointment with you. I should wait for 1 month, by which time I would have died. I will not wait, I will come. That is why we are saying that it forms part of their rights. The other responsibilities are to acquire knowledge on preventive, promotive, and if the circumstances demand, he or she shall seek every professional assistance. If you are sick, go to hospital on time. Don't be home to have your condition seriously deteriorated before you go to the hospital. And to respect the rights and other patients or clients and the personnel of the facility. The charter aims at promoting good relationship between patients and facilities and should not be made optional for some facilities to refuse to adopt. It is true that the charter provides, that is, quality health care could be provided. We must all ensure that the charter is accepted by all. Now, informed consent in Ghana regarding charter. I'm almost done, so don't worry. Section 167 of the Public Health Act 2015, Act 851, has introduced informed consent in Ghana through the patient's or the client's charter. It provides as follows. The principles contained in the 6th schedule shall apply to all persons who relate to patients or clients. Now, let's look at the language. The principles contained in the 6th schedule shall apply to all persons who relate to patients or clients. It is mandatory. Despite the fact that Section 167 has made the principles in the patient's charter mandatory, if you go to the schedule, it is saying a different thing. The schedule, which is part of the Act, has made it optional for health facilities to adopt the charter. The relevant part at page 135 of the law provides as follows. The health service expects healthcare institutions to adopt patients' charter to ensure that service personnel, as well as patients, clients, and their families understand their rights and responsibilities. If you read the body of the law says that it is mandatory. The word shall has been used, and ordinarily the meaning of the word shall is mandatory. Then you come to the charter, then it says that they may adopt. What a contradiction. So here we will do effective interpretation. If I have the body and the schedule is part of the law and the schedule is in conflict with the law, then the law shall prevail. And therefore, whether you adopt or not, a patient can insist a right under it. Now the question as to whether it is justiciable. In law, when we say something is justiciable, that is, does it give you a course of action to go to court by virtue of this one? When we talk about course of action, it's different from enforcement. You can get your judgment, you cannot enforce it. It's a different thing altogether. But this one, we are talking about, can you go to court mainly on that one, that there's a patient charter and the facility has failed to comply its part, and therefore I'm coming to court to enforce it. Justiciability, the course of action. Do you have a course of action? Now, if we resolve the conflict in favor of the body of the act, then you can go and have it enforced. And even in the alternative, where a facility decides not to enforce it, what about the common law position? The common law position that has been enunciated in Montgomery versus Lancashire Health Board. The England Supreme Court has stated unambiguously that where there is no informed consent, you have every right to go to court. So here, assuming the charter is not justiciable, which I hold a different opinion, that the body should override the schedule, even though the schedule is part of the law. When there is a conflict, the body shall override for proper interpretation. You can enforce it. And you can also enforce it in common law. In common law or at common law, what do? You go to court and sue that I came to your facility. You failed to do A, B, C, D, E. And there is a common law position in UK, and I want this court to be persuaded by it. So if assuming the charter cannot be enforced, the charter cannot be justiciable, which I hold it is justiciable, the person can, if you haven't signed it and you are disputing it, the person can go under common law. But if you go under common law, you can bring a lot of things that are not stated in the charter, provided it will be in your best interest. So, Prof, your people, they have to. Because the common law one gives the patient much extensive rights than what is in the charter. But if the person is going under the charter, he is bound by the charter. So here I want to conclude by saying that patients, we are more important, because if there are no patients, doctors will not get work to do. But we must also respect them as human beings. We must also respect the staff. We must respect our fellow patients, because all of them is about what? Human right. And when we talk about human right, it is immaterial. Whether your height is this, it is this, it is this, it is like Father. When Father came, somebody said, hey, Father is tall. And I said that if Father comes to Tanzania, he will be dwarfed. So on this note, I say thank you to all of you.